So welcome everybody to our first QM Law Alumni Series seminar of 2024. I'm Mario Mendez, a professor in the Law Department and also a QM Law alumni. I chair this series, which was conceived as an additional way to nurture our links with our law alumni and to keep us engaged with each other, primarily through discussion of interesting topics with interesting people. We are delighted that alumni from all over the world have been able to participate, both as speakers and through online attendance. The URL at the bottom of the PowerPoint that you can hopefully all see, and which I will also post in the chat box, has the links for many of the videos to the prior seminars, and the sign-up details for the forthcoming seminars will also go on this URL. Just to note that the next two speakers are also on the PowerPoint, albeit with titles to be confirmed. The first of those speakers is a QM LLM graduate, Zachary Phillips, who is now a lawyer in the Ministry of Legal Affairs in his home country, Antigua and Barbuda, and who is acting as counsel in the much anticipated International Tribunal for the Law of the Sea advisory opinion on climate change. And that's taking place in March. And then the following seminar after that one is taking place in April with the distinguished barrister Dan Squires from Matrix Chambers, who is a visiting professor at QM and who has been involved in many high-profile human rights cases, including before the UK Supreme Court and the European Court of Human Rights in Strasbourg. Turning now to our seminar for today, I'm really delighted to be able to introduce Professor Iria Giuffrida. She graduated from our English and European Law LLB program, having spent the year abroad at Leuven in Belgium. And in her final year at QM, she was awarded the Drapers Company Scholarship to study for an LLM at the College of William and Mary in Virginia. This is awarded to one law undergraduate every year at QM, and also one William and Mary JD graduate comes on a scholarship to study for an LLM at QM. It is funded by the Drapers Company, with which QM has long been affiliated. And it's a scholarship that has been running for well over 3 decades and has proved to be a life-changing experience for many, including myself, in fact, as the recipient of this scholarship just before Iria. So a big thank you to the Drapers Company. Following her LLM at William and Mary, Iria stayed on to teach there for a year. She came back to QM to complete her PhD under the supervision of Professor Kenneth Armstrong, who's now at the University of Cambridge, and my colleague Nick Bernard, who is still at QM and who unfortunately is unable to be here with us today. Iria then went on to become a commercial litigator in London and Brussels before heading back to academic life at William and Mary. She is now Professor of the Practice of Law and also Assistant Dean for Academic and Faculty Affairs at William and Mary. Of late, her research has been focusing on legal issues arising from the use of AI, and her talk today is entitled Artificial Intelligence and the Impact on the Practice of Law. She'll be speaking for about 30 minutes or so, and this aspect of the seminar is recorded. We then go to our question and answer session that is not recorded. Can I remind the audience to please keep their mics off during the presentation itself? So thank you very much. And Iria, please do start when you are ready.
Thank you very much, Mario. And I cannot tell you how delighted I am to be here today. So I can impose on you some of the work that I have been doing at William and Mary. I wanted to start with a joke. And the joke is that I'm sort of panting because I'm a bit late. I did not use AI to plan my schedule, and so I double booked myself for the day. So I need to thank not only Mario, but also his fantastic team, because they've been very accommodating for my last minute changes. So what I want to do today is I'm going to try to sort of follow an agenda, give you a very, very basic introduction to AI. As you've heard from Mario, I am not a computer scientist, so this is going to be a legal version of what AI is. I'm going to try to discuss some changes that are occurring already in the legal professions. I'm going to plug a couple of pointers for law students. I hope that there are some, I think there are some in the audience. We'll touch upon some ethical implications of these tools being used ever more frequently, talk maybe about some of the risks, and then I'll leave it to Q&A. Maybe that I'll uncover every aspect with the same degree of detail, just because it's important that we have an opportunity to talk together. Now, one of the reasons why often lawyers are asked to think about the AI is, I think, this one. Right? We're all worried that the AI is coming in, tapping us on the shoulder and say, this is my seat, please move over. And although this is a slightly terrifying aspect and prospect, and it's often presented as the reality for lawyers, I want us to think about what Richard Susskind, who is, amongst many things, I think a futurologist is perhaps the easiest term to describe him. Currently is the president of the Society of Computers and the Law. For many years, this is not something he's been saying recently, for many years, he said that he's invited us lawyers not to think about how technology can detrimentally affect us as our profession, but what technology can do for access to justice and for society as a whole. We are talking more about this. So we certainly have been doing it over the last, I want to say 13 or 14 months, because ChatGPT has hit, so it's been unleashed, talk about the Pandora's box. And so there's much more interest both in academia, in terms of us as academics being worried that, rightly or wrongly, the students may be using ChatGPT, but also in the professional, and I'll compare a couple of uses or approaches in the US and in the UK. One thing, though, that Richard Susskind even himself admits is that the pace at which this development, the technology is moving, is mind-boggling. It's really, really fast. And let's be honest, the law and lawyers are not known to be particularly fast sprinters. We do well in the marathon. We're long distance runners. So what is AI? And this is truly a picture of myself before the pandemic, when I put on 40 pounds as I started to approach this particular issue. What I'm trying to do here is give you a visual understanding of what I understand AI to be. So AI is not a specific term, it's more an umbrella term, or rather not a specific technology, I should say, is an umbrella term that embraces different kinds of solutions that mimic or are intended to replicate certain human faculties. Scientists will group AI in symbolic AI and connectionist AI. Symbolic AI uses sort of the idea of, it creates a model and uses the model to sort of explore the world. And it's the kind of AI that was used probably first, and in applications, especially in the scientific, genetic aspects and medical aspects, biology, etc. Still used, I'm not saying it's not used, it's just one aspect of AI, and it's why perhaps we as non-STEM professionals didn't necessarily bump into this kind of solutions. The connectionist AI tries to draw more inspiration from sort of the way biology creates networks. And so the idea is not to necessarily create a model from the beginning and then let the solution, the AI tool, operate and deploy, if you wish, the model on particular realities, but it's the other way around, is to try to mimic how certain behaviors, whether they're in cells or in the brain, reach particular results. Now, there's many types of connectionist AI solutions. What we have heard over the last perhaps 8 years would fall in what I consider, or I put sort of the blue circle, machine learning. And one of the more advanced forms of machine learning is called deep learning or deep neural networks. And a smaller form still of applications of AI is generative AI. Now, I put generative AI in red because this is what you're hearing the most in the news in this moment. So as I speak through things, be aware that I may be skipping from machine learning as the bigger or the sort of broader form of AI that we've seen over the last 10 years into generative AI, which has hit commercial uses more recently. Of course, generative AI has been, or scientists have designed and worked on generative AI for a while. Now, what I try to tell my law students when we think about artificial intelligence is that technology and AI have a sort of a distinguishing feature. Most of the technology that I used as growing up was in the side of the slide that I call the deterministic kind of technology. The easiest example that I bring is when I open a Word document and I press a key on my keyboard, I know what letter is going to appear on the screen. That's because Word has been coded to respond in a particular way to an input. So the input is me pressing on the keyboard, the output is the letter that appears on the screen and therefore on the Word document. And so everything is predetermined. The fact that Word doesn't necessarily respond to my input is a user error. It's not how the software has been coded. Now that we're shifting to artificial intelligence solutions, we are parting from systems that are predetermined, systems that are told what to do when something happens. If Iria presses a key, then display this letter on the screen. And we're moving towards systems that are called probabilistics. This is because most of the functions that the connectionist AI is developing are based on extremely sophisticated algorithms that give outputs that are based more on probabilistic analysis than they are based on deterministic criteria. Now, there's a mixture of both, of course, but the core of the kind of algorithms that we're talking about when we say artificial intelligence are algorithms that give a probabilistic output. Now, the probabilistic output can be extremely accurate or can be extremely wrong. In some instances, we're able to determine one from the other. With ChatGPT, I think that many of you have seen that it becomes very, very difficult. ChatGPT hallucinates. I do that too when I'm very tired. But the hallucination of ChatGPT is more dangerous. Why is that? Because they sound correct. And the reason why they sound correct is because this tool, and ChatGPT is one of many large language models, this category of solutions are coded for sounding plausible. So the systems have been trained a vast amount of written data, so books and a lot of the nonsense that is being published on the internet, and systems have been fine-tuned to produce an output that is a plausible output to whatever input has been given in. The systems keep using other forms of machine learning, improving based on the sort of the interaction with users. ChatGPT 3.5, didn't used to do that. ChatGPT 4.0, if you subscribe to the more advanced ChatGPT, it is learning from your direct interaction with the system. Now, why does this matter for lawyers? Well, it matters because our perception of reality, I was a commercial litigator, as Mario said, so I needed to establish what happened, right, in the legal disputes that pertain my clients. And this certainty, this is what happened, this is the email, the smoking gun we used to be looking for, never found it. It becomes ever more elusive, ever more difficult to find. Now, I want to spend a couple of seconds to just tell you what right now today are some of the most common applications of AI solutions to our field, to the legal practice. It all started in e-discovery, and I suspect in the audience there may be some litigators and litigators of the old generation. When I started to do e-discovery, the only E, the electronic part, was where the documents were coming from. And I would sit at the desk with many, many other souls, clicking through a software that was programmed to present the document in front of me. And I needed to assess whether the document was relevant, not relevant, perhaps it was covered by legal advice privilege and whatnot. And it was, let me just tell you, frankly, a soul-destroying task. Now that I'm a little bit older, you can see the gray hair. Now that I'm a little bit older, I look back and I realize that I actually learned a ton of law by going through that exercise, because I had the privilege of looking at an enormous amount of contract that otherwise I would have never had to see. Anyway, most of e-discovery today still has a human element. I don't want to suggest that it's all automated. Far from it, still has a human element, but you don't necessarily have army of human beings that do all the processing of the documentation. What AI has sort of stepped in to create categories and accelerate the process of review of the documents and analysis. It really creates little buckets and say, hey, Iria, I think in these buckets there are a lot of documents that look privileged. Please decide whether this is the case or not. Expertise automation is sort of a kind of project management automation. Legal cases can be extremely complicated. Trying to run an M&A transaction is extremely complicated. There's lots of factors that are at play. So some of these AI solutions are being used to manage the process. Legal research, I suspected that the law students on the audience, whether you know it or not, you're already using some AI solutions. Some of the largest legal publishers like LexisNexis and Thomson Reuters / Westlaw are now embedding AI in any number of applications to which your subscription should give you access. Mario will remember that when we were students, we were doing case search by hand. So we would all be in the library. You could see us. We needed to prepare for our tutorials. I don't think I remember how to do it today. So I'm now overly reliant on technical solutions. Document management, as you are drafting a document with the other side, AI solutions can remind you that I forgot to draft a dispute resolution clause, can tell me, hey, hang on, the objective of the deal was X, but this clause drafted in this way does not achieve the objective, actually goes counter it, goes against it. Document management can be used in any other set of applications. Contract and litigation document analysis. This is not just the e-discovery bit. Okay, let me just look at the documents and decide whether this is relevant or not. But there are law firms that literally feed the entire documents that pertain, for instance, to either an existing litigation or a dispute that is about to arise. And the system processes all this data, providing analysis of the documentation, suggesting, for instance, a particular line of arguments, showing where, imagine that the dispute deals with a particular contract and the AI solution can find out that the contract had been novated, but the novations does not include particular elements, and therefore the entire dispute is, for instance, unfounded. So work that we can do, the lawyers have done for centuries, but it's now accelerated and it can cope with vast amount of data that in the past we perhaps would not have been able to cope with at the same pace. Predictive analytics is the bit that terrifies me the most. There are some applications very, very common in the United States. I don't know, and I want to hope these are not yet very used in the United Kingdom, where judgments of judges are analyzed through some solutions that are called the sentiment analysis solutions. And so these tools are able to not only predict what kind of approach a certain judge may have to certain kinds of arguments, but also what cases that particular judge tends to like in that realm of disputes, the kind of words that the particular judge seems to be responsive to, the kind of words that the particular judge does not like. Now, none of this is, again, stuff that never happened before. It did. I can tell you that when I was a litigator, you would talk with either other members of your firm or other colleagues, whether at the bar or not, as to a particular judge's inclination. Is Judge X, how does Judge X take this kind of argument? So I did a lot of work in fiduciary duties. Is this a particular judge that has a certain approach or not? Couldn't do anything about it other than you try to sort of prepare mentally yourself and your material, etc., kind of in a much, much softer way. Some of these predictive analytics that in the US are also used to choose jurors, I find that beyond unethical, but there you go, are now becoming ever more common. I have another couple of slides with some other types of solutions that you can literally find in the market today. Co-counsel is possibly one that you guys would have heard. It's now, it's been acquired by Thomson Reuters, and so it's part of the kind of Westlaw package, and it assists in document review, and it can answer questions about contracts. You feed it a particular contract, and you can say, hey, does this contract address force majeure? And if so, where? Does it, and the answer would be not only whether it does or not, but it will also say the clause that's drafted is unlikely to be a binding clause. And so it provides input, legal input on for the lawyers. There's a bunch of other applications. I don't necessarily want to go through all of them, but just to give you an idea of what is happening today. And I suspect that if I have to present something similar in a year's time, all of this name would be changed into something else, right? These changes are occurring so fast, and you'll see some of the solutions that I've listed have referred to ChatGPT. This is 3.5. I can promise you that this 3.5 are very, very soon moving to 4.0. Now, sometimes students ask me, so what's the difference between the two models? The 4.0 is relying on even more developed large language models. It picks up nuances much better than 3.5. So I don't know if you ever used it, but if you ask 3.5 to write, for instance, cover letter for a job, it'd be a okay cover letter, but anything that you could go online and find a template for a cover letter. If you go on the 4.0, the result is going to be much more nuanced and much more sounding like your voice. So sort of moving ahead, because I'm conscious of time, what are the kind of changes that I want to say I see in the legal profession? This is the result of a lot of research, right? This is not just I see. There's an enormous amount of professionals from all sorts of disciplines that are looking at this space. So on the plus side, we see a growth in efficiency, and it's not necessarily a good thing, because I personally cannot cope with that kind of pace, not just in terms of updating my skills, but also in terms of digesting information. The speed at which my brain processes information is probably slowing down. It's not increasing with age. I have more experience, but my brain is working, naturally in a bit slower. And facts and realities moving very fast around me don't necessarily allow me the opportunity to sort of do the best kind of work that I can. Now, as it happens, and thankfully for clients, I'm no longer practicing, but this is a problem that many, many lawyers are facing. This is not just the long hours. Because of automation, a lot of the tasks that I used to do to relax are gone. So I am expected to produce very high quality work in these really, really long working days. And I can tell you, just physically at some point, I, like very many others, reached a barrier past which you just are no longer able to work. And these systems are going to come in, and they're going to assist us in producing better, hopefully faster work. Professor Susskind will say the access to justice can certainly be bolstered. Imagine that the vast majority of cases are not the cases I used to act on, where they were multi-billion-dollar cases. The vast majority of cases are very small cases. Now, the United Kingdom is certainly first amongst very few other countries, having created an online dispute resolution for small disputes, a small dispute client court. But in jurisdictions where this is not available, perhaps the self-represented litigants have a chance of at least understanding what the claim form is about. And new skills are going to be required. I suspect that all of you as law students have been told you need to understand prompt engineering, which is just another way to say you need to know how to ask questions of large language models. Perhaps as a skill, I spoke with a Microsoft technologist not that long ago who said, I really wouldn't bother because the new kinds of large language models that are coming out don't even need that much care in asking questions. For law students, just a couple of points before I speed the rest of the presentation. What is it critically important that you really focus on is developing the core skills that make you a good user of these tools, while also working between or within the ethical boundaries of our profession. We have an immense responsibility. I just came from a presentation with a panelist, a computer scientist, data scientist, was a representative of Microsoft there as well. And all of them, in all of their presentations, kept mentioning lawyers. We have to work with other disciplines. So the core skills you have to develop, the critical thinking the faculty keeps banging on, it is going to be so, so, so important for your profession. And be open to be a lifelong learner. You're going to finish law school and essentially you're going to know nothing. And then you're going to do the LPC and you come out, you're going to know nothing. And then you move to practice and you're going to work for many years and you still are going to know nothing. So be open to the fact that there's a long process of learning. It's humbling, it's uncomfortable, but it's the way, to some extent, I think it's always been, but we're now much more conscious of how much we don't know. Just a couple of points about ethics, because I think this is critically important. This analysis that I do on this slide is based on the model rule of ethics in the US. Take away the rule number, all these issues, the duty of competency, duty to communicate, how to charge your clients, confidentiality, duty to supervise for senior lawyers, unauthorized practice of law, all of them matter to lawyers across the globe. It doesn't matter what your jurisdiction is. So careful in using these tools. I'm sure that law students have not perhaps yet been exposed to true client material. Maybe if you work for the clinic you have. Well, do not put confidential material on ChatGPT. The minute you put it on ChatGPT, it's gone, right? You have breached your duty of confidentiality. So we need to understand what these tools can do and how we as competent professionals can interact with them. Because the pace clients are already demanding, I've seen it in a year, talking to colleagues, mostly in the United States, clients are already demanding law firms to use AI and other forms of automation to shrink the bill. And the legal fees have always been an issue. Again, it's nothing new. It's just that the magnitude is increasing. And so if a client puts a cap on the fees that they're willing to pay, a law firm is going to have to survive. A law firm is a business. It's going to have to survive with that kind of level of fees. And therefore, they're going to have to find efficiencies elsewhere. So these tools are definitely going to come and they're going to become ever more pervasive. I don't want to bang too much about confidentiality and privacy, but I really encourage, especially young lawyers and law students, to spend time thinking about these issues, because practicing certificates will be lost if a lawyer trips on this kind of issues. And talking about tripping lawyers, you probably have heard the case of Mata and Avianca. This is the first case, at least that we found in the US, where a lawyer used ChatGPT to draft, we call it motion in the US, is an application in the United Kingdom, or at least in England and Wales. And ChatGPT drafted pretty good motion, except that it included cases that were inexistent. It hallucinated the cases. So the other side did their job ethically and competently, checked all the references of the cases that were being mentioned and couldn't find them. They told the judge, you know how this is going to end, in a rather embarrassing few minutes in front of the judge. Now, these two lawyers, because of their age, and I suspect the judge didn't want to necessarily be particularly stringent, got a slap on their wrist and a $5,000 fine. The next round, the next judge is not going to be as lenient. this is a lesson for all of us to be very thoughtful and conscious about how we're using this technology. Now, in the US, this case has unfortunately brought a lot of judges to issue what I call there right at the beginning, standing orders. And so I say a lot of judges, it's really not a lot of judges. The United States is a continent. So there's a number of judges that have issued the standing orders where they clearly indicate one or two things, either telling the lawyers, thou shalt not use any generative AI solution, which is a problem because a lot of generative AI is included in those Lexis and Westlaw tools that we use every day, right? The other kind of approach in standing orders has been, if you use it, you need to tell me how you use it, what questions you asked to the tool, what kind of responses you had, how you changed the responses. And at the beginning, I thought this was a great idea, right? So you have almost like a chain of custody. You see how the bit of information has been changed and processed over time. And then I was drafting the instructions because I thought, brilliant idea. I'm going to use it for my students so they have all to draft a paper as a form of final assessment. And then I started to think, well, what if somebody gives me a 500-page addendum, right? An appendix saying, these are all my interactions with ChatGPT. Would I even look at it? It wouldn't mean anything. It ends up being actually meaningless because nobody's going to look at it. So essentially, you have no degree of control on the quality of the work product. So this is the US approach. There's still 2 weeks ago, was very fortunate to speak at the Chief Justice, the Conference of Chief Justices, where all the Chief Justices of the states, just state courts, not federal courts, were meeting and trying to discuss many issues, amongst which AI was one. And I have to tell you that the impression from reading the room was that they didn't think a standing order was really going to cut it for them. So they're all trying to go back and think about what to do. I think what they need to do is what the England and Wales has done, which is some guidance was published sort of just over a month ago and went through the committee work, and very senior both administrators but also judges were involved in drafting the guidance, which says something like, of course I'm simplifying, you can use it, but be careful. And the concerns are spelled out very articulately, I have to say, in this document. There are other countries like Estonia. They also have a robot judge. Estonia is a very small country. So I'm not sure necessarily we're all going to go that way, but this is just to tell you some disputes are being resolved. There's small disputes, small claims with self-represented litigants, but it's a reality. And in Brazil, there seems to have been a push. Brazil is a jurisdiction, perhaps like Italy, has a really vast backlog of cases. And so some judges are saying, well, we're going to have to use AI to keep shifting, right? We cannot simply sit around and not use the solutions that may allow us to have greater efficiency, because as all the students in the call would have read at one point or another, delayed justice is denied justice, right? Or rather the other way around, justice delayed is justice denied. Whichever way you want to pronounce it or you want to speak about it, waiting to find the outcome of a case is just as good as not having any outcome. So a couple of things to bear in mind before we move to questions. These systems are built by humans, and so they carry all the biases that we have. Bias is generally considered a very bad word. If you call bias, it's an offense. No, we're all biased. I'm immensely biased. I look at the world through my experience, my lens, which of course is very limited, and of course is not representative. But when biases are inadvertently passed on tools, which again, as humans, we've done forever, some problems may arise down the line, problems that had not been necessarily anticipated. So I think the interdisciplinary work is critical, absolutely critical, not just for innovation, because a lot of these solutions are not just coming out of one engineer sitting in one room. These are work of different experts from different spaces, but the solutions are not going to resolve problems. The solutions are there to minimize risk. Interactive AI is the kind of AI that I'm told is coming soon, where you're not even going to have to worry about how you what kind of questions, what kind of interaction you have with it. It will learn what you need, and it will learn how you ask questions, and it will respond accordingly. I'm speaking with this sort of funny emphasis because AI is a tool. It's not a he or a she or a they. It's a tool. It doesn't think. It provides output to input. How it does, as you probably all have heard, is a black box still. Many scientists are working towards explainable AI. The reality is that even if AI were explainable, it would be explainable to some. I still wouldn't understand it. If I'm just told how ones and zeros are going to configure a deep learning neural network, I still will be none the wiser. So all of us are going to have to chug along, learning, feeling uncomfortable, feeling often incompetent, and being curious to understand what some of these tools do and how we can use them ethically with respect of the responsibilities, professional responsibilities that we have, while also achieving what I think everybody is doing by being here, which is administering justice as we can from our individual experience. All right, time for questions. I'm going to stop sharing the screen so that I can interact perhaps a little bit better with members of the audience.
Thank you very much for that, Ira. That was fascinating. So we now go to the Q&A session. This part is, as previously mentioned, unrecorded, so you can